topics, and this being a very important topic, not only for their livelihood, but a time when people are feeling a little lost and directionless. This is a real opportunity for you as association leaders to provide them that, that direction, that guidance, and hopefully a sense of security that they're seeking. We are trying to do that in a number of ways. You will hear about all the resources that are available on nar.realtor/coronavirus. That is where we're housing all of the coronavirus-related materials that are resources for members. We are also sending a member email every Thursday. So every Thursday, you and all of our members should be receiving the weekly update, which is all basically, which discusses the impact that the coronavirus is having on us. The first page is an executive summary, which are excellent talking points for you to use in your resources and communications. And then it's followed by several pages of detailed discussion on health and safety, economic impact, advocacy, and legislative update, as well as the impact on NAR activities. So every Thursday, please make sure you're reading that email and that you're making sure your members read it too. Okay, now without further ado, first up on this meaty seminar of legal issues addressed by the coronavirus or this pandemic is Leslie Mucco, NAR's Deputy General Counsel and Vice President of Legal Affairs. Leslie?
Thank you, Katie. Good morning, everyone. Katie already went over the timeline here. It's just 3.5 weeks. Everything has changed. And on top of that, depending on when you start the clock, we have all been social distancing in earnest for probably 2 weeks now. Probably feels a lot longer since COVID-19 and all the related issues are likely taking over your day-to-day agendas. There's a lot of, it's been an intense time. There's a lot of new issues, emerging issues, and just when you think you have a handle on the situation, lo and behold, something changes and there's a new development. What's even more complicated is that as association executives, you wear two hats. You're not only trying to ensure the continuity of your association's business operations, but you're also trying to serve your employees as well as provide your members with the guidance and resources they need to manage their businesses during this COVID-19 pandemic. So some of the things you're probably thinking about and that are on your mind are how you handle the closing of your physical offices in light of various recommendations by federal authorities, the CDC, local, state, shelter-in-place or stay-at-home orders that are issued. How does this impact your meetings and events that you probably have planned for the coming weeks and months ahead? And then you've also probably been hearing a lot about the legislation that Congress is passing, including the Families First Coronavirus Response Act, and what that means for your association and how you comply with the Act's requirements. So in the next few minutes, put your Chief of Staff hat on, and I'm going to address these items. And then later you'll hear from my colleagues who will discuss the more transactional related issues that your members are facing. So first, I want to make sure to point you to NAR's dedicated coronavirus page. Hopefully by now you have visited it many, many times and you're very familiar with it, but make sure you bookmark nar.realtor/coronavirus and that you check it often, because that's where you will find all of NAR's resources and guidance, and we are updating it sometimes on a daily basis, adding new resources, updating existing guidance as we hear more from all of you and from the members, and different advocacy efforts are taking place. So go there, and you can also find on nar.realtor/coronavirus our dedicated guide for realtor associations. And that guidance is intended to help all of you manage your associations and the issues that you're facing in light of the current circumstances. So Katie touched on this. One of the most important things that you can do as association executive is communicate, and communicate regularly and clearly with your employees and staff about how the pandemic is impacting your association's operations, what it means for the continued operation from a physical standpoint, Is the office going to continue to be open? That will be subject to potentially your discretion or perhaps a state or local order that requires that your office's physical operations shut down. And then coincidingly, what that means for employees and how and where they do their work, and can they do their work remotely, and what are the expectations about that. Also make sure that your staff has a point person at your association where they can address questions or concerns related to COVID-19. And make sure that you're in continued communication with your staff even once they go remote, because as we all know, the situation is changing and developing. So how your association is responding from an operational standpoint is going to change in the coming weeks and months. With 2/3 of states having issued orders regarding essential businesses, many associations probably are now under an obligation to close their doors. And that means that your employees are likely working remotely as they are able. And prior to this, your association may or may not have had experience with remote work. So it could be something very new that all of your employees and yourselves are now forced into as a result of this pandemic and having to quickly adapt. And as Katie said, we're doing the same thing at NAR and finding great success and efficiency and productivity and be able to continue to operate the association and serve members. So if this is something new for you and your teams, NAR's incredible library team has put together a resources page, a topic page on best practices for working from home. And it has a host of resources about effective work from home practices. And it's something that I encourage all of you to review and share with your team so that you can achieve optimal results in this virtual work environment, and also make sure that your members are being continued to be served at this critical time. So there's a resource page at the end of the slide deck. So a lot of what I will mention here is linked at the end of the slide deck. So that topic page and all of those work from home resources you can find in the resources page. So a lot of your offices are likely physically closed right now with employees working remotely. And so that means that your employees are not in the same physical space. There's obviously forced social distancing amongst your employees and staff from your association. But you still need to be thinking about having a preparedness plan. And that plan is intended to help your association address COVID-19 issues in the workplace. So again, your staff may not be currently in the office, but I know it's hard to believe that at some point in the near future, hopefully, we will be returning to a physical space and your employees will once again be together. And your association needs to be prepared as to how to respond to potential COVID-19 issues, whether it's an employee that has a confirmed case of COVID-19 or has been exposed to a confirmed case of COVID-19. You want to be prepared to know how to handle reports of that and how you address it with your staff. So NAR has put together a sample preparedness plan for all associations to use and adapt to their liking, but it's a place to start, so feel free to modify it or use it as is. And it will help you be prepared in the event that there is an issue amongst your staff or a member that comes into the office. It also addresses the issue of members where their buyer or seller clients have confirmed cases of COVID-19. We've heard from many different geographical areas this question come up, so we included that guidance in the sample preparedness plan. So I encourage you to look at that not only for your association, but also to help your members prepare their own plan for how they will respond when clients have exposure or confirmed case of COVID-19. Something to keep in mind when you are handling reports of COVID-19 in the workplace is that you have to be very mindful of privacy concerns. It's not appropriate to reveal the identity of any individual with COVID-19, so make sure that in handling any report that you keep that in mind. Unless an individual has given very clear consent to be identified, you need to maintain that privacy of the individual and their diagnosis of COVID-19. A lot of employers are also asking, again, this will be more relevant potentially down the road or for associations that are still open and operational from a physical standpoint, but employers are asking whether it's appropriate to do a temperature screen of employees. The EEOC recently published a bulletin clarifying that it is okay to do a temperature screen of employees, but think about that before you take that step. First, I think it's pretty unlikely that your staff or yourselves are trained medical professionals, so that's one thing to consider. And also think about social distancing. Just by virtue of having to take a temperature screen, you're getting extremely close to an individual. And whether or not someone has a temperature is not indicative of whether they actually have the virus, and it might cause someone to ignore other symptoms. So if you're tempted to do a temperature screen when your employees are back in the physical workplace, really give it some thought and consider potentially encouraging employees to self-evaluate and maybe complete a simple health questionnaire before they do return to the workplace instead of doing that temperature screen. So next, I want to talk about your upcoming events and meetings. Just like NAR, I'm sure all of you had a lot of exciting events and meetings planned for the spring and summertime and fall. And right now, you're probably taking stock of what the pandemic means for being able to continue to hold those events, whether it's advisable or even permissible in some circumstances. So you're probably familiar with the CDC's recommendations as well as the White House's recommendations that make clear that we're to adhere to social distancing, requiring 6 feet or more between people, which is pretty hard to do when you have a meeting or event, and also to avoid gatherings of 10 or more persons. So that recommendation pretty much eliminates most meetings and events that would be held. And then when you think about the various state, county, and local orders that are being issued, a lot of these orders are incorporating those recommendations and may even serve as a prohibition or demonstrate an extreme inadvisability to continue to hold those events during the effectiveness of the order. Those orders are also they're in place right now, but we also have to be mindful that they may be extended. Just like the White House just extended, President Trump announced the extension of the recommendations regarding social distancing and gatherings until April 30th. So we'll likely see more activity from the state in that respect as well. So you really need to start thinking about what you do about your meetings and events. Do you move forward with them? Do you postpone them? Do you cancel them? Turn them into a virtual event like this was? And the orders in your geographic area will be very instructive as to what steps you take. And with the president's guidelines being extended until April 30th, that may dictate the outcome of how you proceed. So right now, you'll want to start looking at your contracts that pertain to any of the events that you have coming up in the next weeks and months, and understand what your cancellation rights and obligations are. And you'll want to specifically look to see whether or not your contracts have a force majeure clause included as part of the contract. Force majeure clauses are really great. They're very, not very often, executed, but here, if you do have a force majeure clause, it could help protect the association and allow the cancellation of the contract without penalty. Because force majeure clauses generally excuse a party's performance when supervening circumstances make a party's, prevents a party or impedes a party's performance. So here, with the pandemic, a global health crisis, a threat to the health of attendees, et cetera, you very well could, if you have this language in your contract, assert it and cancel the contract without penalty. This is going to be very fact-specific on the force majeure language in your agreement. You also have to think about where the event is taking place, but we are generally hearing great success with entities being able to invoke force majeure clauses and cancel events from April to May using both the CDC and the White House's recommendations and the support of various state and local orders that are in place. For events beyond those timeframes, things are still evolving. We saw the extension of the White House's guidance, and again, state and local orders could be extended. So you'll just want to continue to think and evaluate about events that are happening or to occur a little bit further in the future. And I encourage you to consult your legal counsel to determine the right time to assert your force majeure as the situation continues to evolve. The last thing I want to briefly touch on is the Families First Coronavirus Response Act. And this act is really an unprecedented move by Congress to provide paid sick leave to employees. There's several key things that you need to know about the Families First Coronavirus Act. First, it takes effect tomorrow, April 1st, and it applies to all private employers with less than 500 employees. That likely means that most, if not all of you attending this webinar are required to comply with the Act. So if you have less than 500 employees, which means 499 or less, you are subject to compliance with this Act. And what this Act does, it provides two different types of leave. It provides emergency paid sick leave and extended FMLA leave, and I'll get into what each of those mean. But I do want to make clear that the Act is not retroactive, so if you've been hearing about this and already been providing employees with any of the rights or paid leave under the Act, it's not retroactive, so nothing that you've provided employees up till April 1st counts towards the paid leave that employees are entitled to under the Act. It takes effect tomorrow, and employees as of April 1st have a right to this leave. Also, some other things you want to keep in mind is that this leave is in addition to any other leave that you may already be providing your employees. This does not diminish an employee's right or ability to take other paid leave that they have available through the association or their employer. And you cannot require employees to first take other paid leave instead of the leave that they're entitled to under the Families First Coronavirus Response Act. The good news for employers is that the leave is designed to be cost neutral, so employers can receive a direct and equal payroll tax credit for the cost of the leave that they're providing to employees under the Act. So the first act, the Families First Coronavirus Response Act, has two acts underneath it. The first one is the Emergency Paid Sick Leave Act, and that entitles employees to up to 10 days of paid sick leave. And the paid sick leave is available to all employees. There's no service requirement, so it doesn't matter if the employee's been with you 1 day or 10 years. Every single employee that is employed by the association has a right to take this leave. And the leave can be taken, these 10 days of paid sick leave can be taken for one of 6 reasons. If the employee is subject to a federal, state, or local quarantine or isolation order, if they've been advised by a healthcare provider to self-quarantine, if they're experiencing COVID-19 symptoms and seeking medical diagnosis, caring for an individual subject to an order or self-quarantine, or if they need to care for a child because their school or care provider has been closed or is unavailable due to COVID-19. And then there's a 6th catch-all reason, which is they're experiencing any other substantially similar condition specified by the Secretary. So if an employee is experiencing any of these 6 reasons that they need to take this paid sick leave, employees are entitled to pay. And the pay depends on what reason they're taking the leave for. So if an employee is taking the leave for any of the first 3 reasons, they're entitled to 100% of pay up to a $511 day maximum and a maximum benefit of $5,110. If the employee is taking it for reasons 4 through 6, then they are entitled to 2/3 of their regular pay up to $200 a day and a $2,000 total. So that's the paid sick leave. The other type of leave provided for under this new act is emergency paid extended FMLA. And what this does is add another qualifying reason why an individual can take FMLA leave. And unlike the emergency paid sick leave that we just talked about, the extended FMLA does have a service requirement. So only employees that have been employed by the association for 30 calendar days are entitled to take this leave. And the extended FMLA is an employee is entitled to take it for only one reason. So with the paid sick leave, there were 6 reasons an employee could take those 10 paid sick days. For the extended FMLA leave, there's one reason that an employee can take it, and that is where an employee is unable to work or telework because they need to care for a child under the age of 18 and that child's school or care provider is unavailable because of COVID-19 related public health emergency declared under federal, state, or local law. So here it's 12 weeks of FMLA, just like the traditional. The first 2 weeks would be paid under the paid sick leave, those 10 days that an employee is entitled to. And then the remaining 10 weeks would be paid at 2/3 of their regular pay, up to $200 a day. So an employee is entitled to up to $10,000 in the aggregate, plus the $2,000 from the emergency paid sick leave for a total of $12,000 in the aggregate. Here again, it's designed to be cost neutral to employers, so employers can recoup the cost of this through payroll tax credits. I want to be clear that this does not give employees an additional 12 weeks, so employers are entitled to 12 weeks of FMLA during a year time period. And those 12 weeks, the 12 weeks under the extended FMLA are not on top of what an employee would traditionally take FMLA for. So whether and how much an employee is entitled to take under this extended FMLA depends on whether the employee has already taken FMLA within the relevant time period. So if they have already taken some FMLA prior to this, they may not be entitled to a full 12 weeks. It'll just depend on what the employee's circumstances are. As an employer, you are required to provide notice to your employees of their rights under the Families First Coronavirus Response Act. Traditionally, that would be done just like other rights that employers are required to post to their employees and notice to their employees by posting in a conspicuous place. Here, that's not practical because a lot of employees are remote at this point. So you can accomplish and satisfy this notice requirement by either emailing a copy of the poster, which the DOL has, the Department of Labor has a sample poster, also linked in the resources. You can send a copy of that poster to your employees through an email, or you can post on your internet site. Both would be ways to satisfy that notice requirement. There are a lot of nuances and questions about this leave. It was put through in a rush, of course, an emergency response. The Department of Labor is providing additional guidance and regulations regarding the Act. And I have linked the FAQs and the guidance from the Department of Labor in the resources. But I do want to point out a few things before I end here about the Families First Coronavirus Response Act that you should keep in mind. First, if an employee does come to you and want to avail themselves of any of the leave under the Act, you should require that that employee provide you with documentation in support of why they're taking the leave, and make sure that you retain that documentation, because that will be very important if you're planning to seek that tax credit that is available to employers who provide this leave. So what type of documentation would satisfy this? So you could have a copy of the quarantine or isolation order that the individual might be subject to, the name of the healthcare provider that advised of self-quarantine. In the case of a school closure, an email from the employee or a school official or child care provider could suffice. The FAQs provide very detailed information about what type of documentation could satisfy that requirement. So we are awaiting more guidance and regulations from the Department of Labor, but recently the Department of Labor did indicate that there would be a 30-day non-enforcement period as long as employers act in good faith. So this should give employers like yourselves comfort in trying to administer your obligations under the Act, knowing that there will be no enforcement action taken for the next 30 days, because we are still waiting for a lot of clarifications from the Department of Labor. There's also a small employer exemption that's available to small employers with less than 50 employees, which essentially requires an employer. So many of you might have less than 50 employees. And if you want to seek this exemption from the Department of Labor from compliance with the Act, you would have to demonstrate that compliance would jeopardize the viability of the business as a going concern. And as far as we understand it currently, the only the only basis for that exemption or exemption that would be available is for employees seeking to take that leave in relation to caring for a child. That's what it appears is the most recent guidance from the Department of Labor, that the exemption would only apply where an employee is seeking to take leave related to caring for a child. So NAR has a number of resources on this act, and those are also linked in the resources slide, so I encourage you to go there. And with that, I will turn it back to Katie.
Thank you, Leslie. So a ton of important information for employers, associations, brokers, just anyone who's an employer. Reminder that all the resources we're talking about are available on our website. This webinar will also be available to re-listen to get the details. Leslie, before we switch gears, I want to ask a couple questions that we received in the comments. And so one was, can you confirm what, who this pertains to? Is this employers with fewer than 500 employees, but still having more than 50 employees?
No, it's any employer with less than 500. So you have 499 to one employee, this applies to you.
And then your slide, which I'll put up here, on emergency paid sick leave, says that if you're unable, the first reason is if you are subject to an isolation order. Do you know, does that include the government executive orders for shelter in place?
It does not. It does not pertain to shelter in place or stay-at-home orders. It's if you yourself are subject to a specific quarantine or isolation order based on your personal circumstances.
And then the other question was, what kind of proof is required for employees to show their employer to take advantage of these benefits?
Yeah, so I went through some of the examples of documentation. So the Department of Labor does have good guidance on this. To the extent it's good, but there is guidance in the FAQs. So your employee would have to provide or could provide a copy of the isolation or quarantine order that they are subject to. They could just provide the name of the healthcare provider who advised them to self-quarantine, or documentation from the healthcare provider advising them to self-quarantine. So it sounds like it could be just an employee providing an email to the employer with, I've been advised by XYZ healthcare provider that I should self-quarantine, or they could provide that directly from the healthcare provider. I imagine that's because, as we all know in our hearing, is healthcare providers are inundated, so requiring a healthcare provider note would be very burdensome for an employee to have to obtain in order to take this leave. And then if the reason that the leave is being taken is related to care for a child, there's a number of ways. It could be an email from the employee or the school official, something that was posted on the school or daycare website, or a note from the child care providers themselves, letting them know that they're not available. So there's.
And thank you. And then finally, does this pertain to part-time and or temporary employees hired by the association?
It definitely pertains to full-time, and it definitely pertains to part-time. I am not 100% sure about temporary, but it definitely pertains to part-time. I can try to find the answer to that and answer it before the end of the webinar, but I don't want to say off the top of my head.
Thank you very much. A lot of great information. We have so much information in this short amount of time that on this next topic, I'll only spend 30 seconds, because this is a meaty, robust topic that our advocacy team is all over, and you will be seeing videos, webinars, and resources on it. Please check out the main message. Please go to nar.realtor.com/coronavirus and click on this political advocacy tab that you see here on the screen. It contains an immense amount of information of the advocacy efforts at the federal level to put some money in the pockets of our members, to provide some relief to homeowners. Specifically, the second bullet point that says Coronavirus Aid, Relief, and Economic Security Act, also called the CARES Act, provisions for realtors and their consumers. It includes a drop-down menu of all of a summary of the provisions of the CARES Act that is important to our members and their clients. It touches on the direct stimulus of the $1,200 and $500 that people will be receiving from the federal government. It talks about the Pandemic Unemployment Assistance, PUA, that is now available to independent contractors for the first time ever. We're getting lots of questions about the unemployment insurance and how members can take advantage of it. Your state agencies for unemployment will be administering the programs. So associations, please make friends with your state agency, unemployment insurance agency, because they have the rules and the processes to allow members or independent contractors to take advantage of this resource. Does it matter if your state has deemed real estate essential service? No, it does not. Members or any individuals who are unemployed or not receiving income are potentially eligible for this benefit. So again, read our information on it on this website and look at your state websites. Also, there's information about mortgage forbearance that's happening now, moratoriums on evictions, student loan forbearance, SBA small business loans. Our members are going to be able to take advantage of small business loans and economic injury disaster loans and grants. A lot of resources coming their way. So please check them out and please redistribute our FAQs and our guidance on these advocacy efforts that we are updating daily. So come early and come often. All right, we're going to switch gears to the Katie Garrity, Associate Counsel, and she can talk about essential services efforts happening at your state. Katie?
Thanks, Katie, and good morning, everyone. As you know, we have created and have been updating daily this spreadsheet that tracks each state's executive orders or health directives, either mandating a shelter in place or stay at home or the closure of non-essential businesses. The states are taking a very different approach to how they respond to COVID-19. So we're doing our best to stay updated and keep this tracker live. And those variances can be anything from whether or not businesses have to close to what is actually considered an essential business. So what this spreadsheet does is it sets out each state whether or not there is an order, the effective date of that order, how long that order is effective, and whether or not real estate operations can continue during that time. We've also included links to these orders as well as links to other websites that may be helpful to you. And where applicable, we've also included links to letters that your associations have drafted to your respective governors, asking them to consider real estate an essential business. For the approximately 10 states that do not have any statewide mandate, we're tracking these developments on a county or local level as we become aware of that information. So if you have more information, feel free to send it over. One update that you'll see on the most recent spreadsheet, there's some language that is in red font. Over the weekend, Katie Johnson sent out an email showing that the Cybersecurity and Infrastructure Security Agency, what I'll call CISA, updated their list of what they consider essential critical infrastructure workforce. This list now includes residential and commercial real estate services, which is great news for every state that bases their determination of what an essential business is on these CISA guidelines. So what we've done is for states that have been affected by this update in a good way, that font is in red for the time being. It's not permanent, it's just so that you can see what changes this actually affected. If you have questions or updates based on your state, please feel free to send them over. Like I said, we want to keep this as up-to-date and relevant for you as possible. The last thing that I'll mention is we are not making this spreadsheet public. Instead, we view it as a tool for you to advise your members and to see how other states are handling the issue. We hope that it's been helpful and that it continues to be helpful.
Thank you, Katie. We've gotten lots of good feedback. It definitely has been helpful for many. And I'll just add that I posted a message in the general forum hub today. We're getting lots of questions of what does it mean to be real estate essential services? It means a lot of things. Ultimately, it means only what is set forth in your state's executive order. So you and your members are encouraged to know the order well and to abide by the order, no matter what it says. So please take a minute to check out that hub post as well. So now we are going to, and if you have questions, then we might have time at the end to address some more questions, but we're gonna turn it over to Deanne Romarowitz to talk about residential transaction issues that many of our members are facing today. Deanne?
Thank you so much, Katie. And before I dive into this information, I want to just assure everyone, maybe give you a little breathing room. You've had a lot on your mind. The excess insurance premium, if you've been meaning to get to your application, you have another month. We were able to extend the deadline from April 1st to May 1st. So hopefully that gives you a little bit of breathing room. Okay, let's get into residential transaction issues that many of your members are facing. As the coronavirus outbreak has spread across the country and disrupted life as we know it, NAR's guidance for its members has also evolved. How can they continue to do business? Our guidance has evolved to meet their needs. So for example, on March the 4th, which was the first day that we produced our guide for realtors, the common questions were things like, can I ask a potential buyer if they've traveled recently? That backdrop was we had about 80 cases, according to the CDC, in the United States. And we were just seeing the first travel restrictions of people coming in from China being quarantined for 14 days. So that's what we were seeing then. Now, fast forward 22 days later, and the questions became more intense as we started seeing shelter-in-place orders. And now the question is, how can I still conduct my business under a shelter-in-place order? So we've had multiple pieces of guidance between March 4th and March 26th. Our most recent is the shelter-in-place guidance for COVID-19. And links to these guidance documents are available at nar.realtor/coronavirus. As other presenters have said, that's kind of our clearinghouse for all of our efforts to assist you as well as the members during COVID-19. So we do encourage you to go there, and there's links to all of this also at the end of the presentation. Now, in an ever-changing situation, it can be difficult to navigate uncharted waters and to know how to move transactions forward or to even provide guidance. Where do you begin? But two things can help you navigate through this issue, and that is having a decision-making standard and, frankly, going back to some basics and remembering some basics about real estate transactions. So early on, NAR developed a decision-making standard that we've been using as we craft our guidance, and we encourage our members as well as our associations to use this standard as well. And this is it. How can I provide first-class client service and move the transaction forward while still demonstrating care for the well-being of others, reducing the risk of exposure to and spread of COVID-19, and perhaps most importantly now, complying with local, state, and federal public health policies. So anytime we're faced with a question, this is our touchstone. This is what we come back to. Still providing that first-class client or member service, moving transactions forward, but still being in compliance and keeping everyone's well-being at the top of mind. Now let's talk about good transaction management. The basics don't change regardless of the situation. I know everyone's like, we've never seen this. This is so crazy. This is, we've never had to deal with any of this. But the basics of good transaction management stay the same. First of all, comply with the law. We cannot say this enough. Adhere to state and local restrictions, shelter-in-place orders, and as Katie Garrity mentioned, whether real estate is an essential service in your area. Next is to communicate. Communicate with clients. Communicate with other parties to the transaction, and communicate not only what you know, but what you don't know. Keep everyone advised as much as possible. And while you're communicating, don't panic, be patient, and encourage clients and the escrow officers, if there's attorneys involved, encourage everyone to do the same. Everyone is facing this situation. No one has had to deal with any of this before, and you'll all need to work together to figure it out. So communication, it's kind of a trite saying, but communication really is key to dealing with transactions during COVID-19. Next, you'll want to make sure that members are reviewing their legal contracts and using addendums where needed to address potential extensions. Now, many associations stepped up right away and started drafting COVID-19 addenda for their members to use. One thing we do want to discourage, though, are members coming up with their own addendum, coming up with their own language. That could actually cause more liability than they're trying to prevent. So it's really important that members are using association drafted forms or going to their broker and legal counsel to help them draft the contract language that they need for their particular transaction and circumstance to extend deadlines or whatever the case may be. Remember, the buyer and seller are always free to work together to amend the contract and obligations based on any new circumstances. So that is, again, a basic legal principle that is so important right now. And then the fourth kind of basic is using best practices. And what that means today, things like virtual meetings and showings, eliminating where possible any sort of physical interaction, using electronic signatures with platforms like DocuSign. RON is remote online notarization. Many states have already have remote online notarization in place, and many more under emergency executive orders are now adopting remote online notarization for things like real estate, even notarizing wills. There's many legal documents that need remote online notarization, and it's incredibly helpful for real estate as well. And several areas also have electronic recording, so that can help transactions move forward. Now, our incredible library team, that's a little bit later. So we're embracing best practices. I do have a slide that has some resources for the members that have things, tools that they can use while they're embracing best practices and going virtual. Now, over the last few weeks, NIR has developed a series of guidance documents. Again, these are all available at nir.realtor.com/coronavirus. The first is the Coronavirus Guide for Realtors. It provides general information. We've also got a specific open house guidance document that we're updating as needed. We have a comprehensive transaction document that talks about what to do with listed properties. How do I keep that going? Properties in escrow, we address everything from amendments, inspections, due diligence, appraisals, loan approvals, closing and recording in that transaction guidance document. And then again, our most recent document is that shelter-in-place document. How do you continue to do the business of real estate while subject to a shelter-in-place order? There are a couple other pages that our library team has put together for you. One is a clearinghouse, a virtual showing and virtual tour resources, and our transaction guidance after natural disaster. Links to these are on the slide at the end of the presentation. Now, we're doing our best to keep all of our guidance documents updated, so please check back regularly. And as a ship changes course in the water, our guidance may also be refined as we're getting new questions from members as things are changing and evolving, so will our guidance. And we will continue to use that decision-making standard to provide the best possible guidance at the time with the questions that we're receiving. So with that, I'll ask Katie if we've had any questions come up.
No, we're good. Thank you, Deanne. Lots of great information, no specific questions on this topic. So Deanne, I should also mention, is the team on our legal affairs team who creates and is in charge of all these resources. So Deanne, you're doing an amazing job, and we really appreciate it. Charlie Lee, talk to us about commercial transaction issues.
Yeah, I'm happy to do it. It's a pleasure to speak to everyone today. I'll cover two topics. I'll discuss commercial transactions that can arise due to this pandemic, and then I'll share information about what states have done regarding licensing renewal and continuing education deadlines. So let's first talk about mitigation efforts. It's prudent and reasonable for landlords and property managers to engage in COVID-19 mitigation efforts. In fact, building tenants and guests expect no less. Screening individuals who enter the building, particularly if it's like a long-term care facility, nursing home, or where you have a lot of elderly as tenants or residents, this would be appropriate. Just make sure that everyone is being treated equally and fairly, that they're being asked the same questions to avoid any discrimination or fair housing issues. The building also should have a plan to deal with any suspected or confirmed case of coronavirus. The plan should include steps to alert all tenants, residents, and parties who share facilities and for contacting local health and government officials and following their health and safety protocols. So let's move on to key lease provisions. You may have heard that some major retailers, such as like Cheesecake Factory, Subway, and Mattress Firm, are notifying their landlords that they won't be able to make rent April 1st due to the pandemic. With April being tomorrow, landlords and property managers may receive similar notices from their tenants. So it's important to review your leases to know what rights in the lease are provided or available for tenants to seek. So here are some provisions that you'll want to be aware of and that tenants may likely to claim. There was some discussion about the force majeure provision. Prior to this pandemic, this was just a boilerplate provision that contained standard language, but during this pandemic and for some time after, you'll probably hear a lot of talk about the force majeure clause. This contract provision, just generally, it permits parties to suspend, excuse, or terminate their obligations due to enumerated circumstances beyond the party's reasonable control. You'll want to check to see what the force majeure clause in your lease says and how it may be applicable to the pandemic. Words you'll look for are like pandemic, quarantine, acts of government, or pandemic. If you see those words, then the clause is more likely to be applicable. If the force majeure clause is general and broad, it also is likely to be applicable, but ultimately these things are going to be subject to interpretation and may need to be resolved in court. The next clause is the casualty clause, and this provision generally covers situations where there's been some damage to the physical structure or structural integrity of the building, like from a fire, flood, or an explosion. While a pandemic isn't typically considered to be similar to a fire or flood, tenants may look to assert this provision, claiming contamination or disruption to their ability to use their leased space qualifies as a casualty. This is a novel argument, but this is something that a lot of experts are expecting for tenants to assert and look to claim, and it's something that we'll be watching closely to see how the courts decide on this. Condemnation in eminent domain is another provision that tenants may look to claim, especially with states declaring states of emergency and ordering shelter in place or stay at home. Tenants whose lease spaces were forced to close may look to claim that the government took control of their premises, with these regulatory actions. So with these orders and the pandemic, though, being temporary, if this provision is applicable, we expect that the relief would be partial, and this relief is normally sought after by going directly to the government. Also, it's important to note that these claims are going to differ based on jurisdiction, as states' constitutions may have broader takings clauses. And then lastly, landlords and property managers will want to check to see if their leases list any landlord services as an essential service. If an essential service is described, you'll need to know what it says happens if an essential service is not provided, and then if there's a time frame or period in terms of when that essential service is supposed to be delivered, and whether it allows for a force majeure event to excuse the landlord or property manager from delivering that performance. With all of these clauses, if they're applicable, you'll need to know what rights they provide the tenant. Does it provide the tenant the right to delay performance, such as pay rent until after the pandemic is over, or excuse performance, meaning the tenant gets a rent waiver during the pandemic, or does it give the tenant the right to terminate the lease? Clearly, these rights have very different implications, so you'll want to know what they say and how to plan accordingly. So in terms of rent relief, landlords have their own financial responsibilities, so it's impractical for them to give all their tenants every relief and assistance that's requested. And with such a rapidly changing landscape, it's important to reserve the ability to adjust and act in accordance with circumstances that may not currently exist. Therefore, landlords are recommended to limit offers of relief to 30 to 60 days, look to offer a rent deferment instead of a rent waiver. The tenant should be offered to have their rent payment spread out through, can be offered to have their rent spread out through higher future payments, or they could agree to extend their lease on account, to account for the months that they don't pay rent. Not all tenants need the same level of relief, and some may be better suited to deal with challenges than others. And so one tool that you'll see in the resources page is a template rent assessment application that was shared with us. And this will help you determine what relief the tenant that's seeking it may need. And then also be sure to know whether your state has issued a commercial eviction moratorium. This will affect the leverage that you have in these negotiations. California, New York, and Nevada are some of the states that I'm aware of where they've issued a moratorium. In terms of best practice, as we're going through unprecedented times and with things changing so quickly, there are no textbook answers or solutions to many of these issues. The best thing to do is to be proactive and to reach out to tenants, share information about government relief programs, and work together to find solutions. Tenants may expect landlords to also apply for some of that relief and to share in some of the relief that they receive. And this is just the best way to avoid potential vacancies. And then in my last topic, I'm just going to share information about what states have been doing to address the challenges members are facing with meeting their license renewal and continuing education deadlines. Fulfilling these requirements are now more challenging with many of the government offices, their services, and education providers being limited or having their services suspended. Therefore, NAR has been collaborating with Arello to survey this real estate commissions to learn what they are doing or what they're planning to do to address these issues. We've also contacted state education directors directly because some of them are just more quickly to respond. And what we've learned so far is that 10 states have taken official actions to extend their deadlines. With some of these states, they've just simply moved it to a specific deadline that's later, or other states have issued a period that is going to go into effect once the state of emergency is ended. We've also learned that there are 5 states that are prepared through on a more informal level to grant extensions to individuals who can't meet their deadlines due to the pandemic. For the other states, we're waiting to hear from them, and then this information is being collected and they're going to be put into a table and they'll be shared on the NAR website once it's complete. If a state decides not to change its deadlines, I believe it's because they allow distance education or because they provide general extensions based on individual circumstances. And so brokers should really be aware what their state's deadlines are and whether their states accept online education. So this concludes my presentation. So I'll hand it over to Renee.
Thank you, Charlie. Lots of more good information, and well done to all of you states and your advocacy efforts to get these extensions and to work with your regulators to understand the obstacles that members are facing to comply with CE and other licensing deadlines. Last but not least is the great Renee Galicia, our Director of MLS Engagement, who's been working hand in hand with lots of associations, MLSs, and large brokers to understand this MLS issues presented in this pandemic. I will add, it is noon on the dot, and we're supposed to be ending, but if you could just hang on with us for 10 more minutes, you'll get this great information, and then we might even have a couple minutes left for additional Q&A. So Renee, hit it.
Thank you, Katie. Hello, everyone. I'll make it quick. I just want to touch on a couple of the items that your associations and your MLSs may be getting asked about, especially by members in this time where showings of properties have been impacted. So I'll touch on 3 major items, and then I'll close with a quick update on the clear cooperation policy. First, the biggest issue by far that we've been getting questions about and have had several discussions with our MLSs and associations has been regarding the handling of days on market. That was probably one of the first issues that came up as soon as the shelter-in-place orders were handed down at the local and state levels. So the question generally comes from member or is posed by a member: can you suspend or otherwise suppress days on market within the MLS or a public-facing website that the association or MLS may control? And recommendation would be to, at this time, not take a look at and consider not suspending that counter. The overarching or the guiding principle that you want to consider is helping members share that information with their clients and sellers about the true picture and the advertising, ensuring that they're able to accurately represent that information, their marketing and other representations that they're putting out online. Suppressing days on market effectively would remove that ability from members to accurately communicate that information out. But the conversation should be revolving around a consideration whether to suppress in certain areas over suspending that counter, wholesale suspension of that counter. A major concern with suspending days on market is that suspending could lead to factual inaccuracies within the database. In other words, once you make a determination to continue accruing days on market for your listing or the showing of that counter, there's no way, there's no easy way within the database to designate or otherwise highlight that period of time that days on market was suspended or why or what led up to that. The other consideration there is that an increase or potential increase on days on market because of our current market conditions generally apply equally to all listings. In other words, no one listing is being unfairly impacted by an increase in days on market because the market conditions are such where if there is an increase in days on market, it would apply equally across the database. And I'll touch on more on accuracy of data in just a moment. But that also leads to conversations that you may be having locally about what is the market, what is days on market tracking. Does it only track market conditions during a certain period of time and not others? And the challenge there is that from a national MLS policy perspective, we don't have one standard that mandates how days on market is calculated. The RISO, the Real Estate Standards Organization, has some great information on their data dictionary, but they too leave the decision of how do you program in and track days on market to local MLSs and associations. We have seen some MLSs and associations suppress the counting of days on market on their public-facing websites and opting to leave that information visible within the MLS platform to put that responsibility on the members to translate that market information to their clients. But we've also seen other MLSs not suppress the days on market within their website and opting instead to put in some disclaimer or otherwise highlight a statement that days on market may be impacted by ongoing market conditions. You may also want to, as you're considering or fielding these questions about whether or not to suppress or suspend days on market, you may want to speak with your neighboring MLSs and associations, in particular those that you have entered into data sharing agreements with. The consideration there would be if one MLS chooses to either suspend or change something or add a status or some different handling to account for current market conditions, how does that translate over to you or vice versa, and how do you map that data back and forth? That may also present some other challenges for members and for the associations and MLSs. Moving over to one final consideration on days on market. We have gotten questions, and again, from the national level and within our MLS policy, we don't mandate or otherwise control statuses. That's a local market decision that should be guided by RISO Data Dictionary. But the question we get commonly is, should we be tying or should we continue to tie availability of showing a property with active status? And we've seen two different handlings. There may be others, but generally two different handlings by MLSs where some MLSs have implemented an active status to reflect just simply the availability of a property, while others have tied both the availability of the property and the availability to show that into one status. So you may want to take a look at that and consider some different handling if that would ease or help you answer or provide that avenue for members over wholesale suspension of days on market. Open houses. We very quickly saw various MLSs suspend or suppress the open house field. So taking away the ability to schedule open houses, whether it's public open houses or broker tours. And that was in response to state and local orders to either shelter in place or to reduce the number of people congregating at one time. A best practice that has come up as of late has been, rather than a wholesale suspension of that field as well, maybe considering retooling existing open house fields and giving members the ability to schedule virtual open houses. Deanne provided a link or showed a link to virtual tours and virtual open houses, and that may be a solution, a better solution, so that members can still transact and can still market their properties, especially for sellers that may find that they're in a need to quickly sell their home or get their home on the market during this ongoing pandemic. Giving them the ability to schedule virtual showings may be beneficial rather than simply suppressing the open house field itself. In addition to that, you may consider, if you don't already have within your MLSs, the addition of a virtual open house URL field so that listing brokers can add that URL, whether it's hosted on a website or an unbranded website or other URL hosting platform, where they can help facilitate that sharing of that virtual open house to not only to other members, but also to potential IDX websites and syndication websites, portals, and the like. Also taking a look at what do your showing rules look like, so reviewing your existing MLS rules to see if there are any limitations within those existing rules that would otherwise prohibit a response to ongoing market conditions where physically showing a property may not be possible. Finally, or just before I get to the clear cooperation policy, virtual tours, virtual showings, virtual open houses. In the past, we've heard that portals and other syndication websites were removing URLs from the property description field prior to loading those properties onto their website. You may want to, if that's the case in your local market, you may want to have or open up discussions with those syndicators, whether it's a portal or other IDX providers that may be removing those fields, just to provide some additional options to listing brokers on their ability to share links out to virtual tours, virtual showings, virtual open houses. Final item there is just always keep in mind copyright considerations. We have some great resources on our website at nar.realtor. If you search for copyright or the article, Who Owns My Photographs, that becomes even more important today, where you may have others or other third parties, not necessarily your listing broker or somebody within their office, going out and taking pictures of property or facilitating virtual tours or recording the property, just making sure that whatever information is being input into the MLS or provided to the association is being done so with the proper permissions in place. And finally, to wrap up, just a quick update on the clear cooperation policy. So members of the NAR's MLS Tech and Emerging Issues Advisory Board met and discussed, among several items, the impact of COVID-19 on MLSs and the real estate industry more broadly. As you know, we have the policy that was voted on in November comes with a May 1 implementation deadline. The advisory board members determined that it is important to keep and maintain the May 1st, 2020 implementation deadline for the clear cooperation policy. The thinking there, especially in light of current market conditions, becomes even more important to ensure that all listing information is made available through the MLS. That being said, we're mindful that MLSs and associations are being impacted by the ongoing pandemic. So your NAR staff and our resources, as always, remain available to you. If there's any way that we can help, we can help in facilitating membership events through a web meeting platform, or providing our staff resources to either provide a video update or individual meetings with brokerages via WebEx or Zoom or any other platform. Please reach out to us. Let us know. We're here available to help you out. So with that, I'll take your questions and I'll hand it back.
Thank you, Renee. Again, great information. We're getting a lot of questions about virtual tours, and both you and Deanne touched on it. So I'll try to address some of those questions succinctly. Virtual tours are a good way to continue providing services remotely, virtual showings. The first question is how do you make that happen? How do you get the tours? First and foremost, everyone must abide by their state executive order regarding stay-at-home or shelter-in-place. If you are in a state that deems real estate essential services, then you have some options. In some states, well, in probably no states, although I'm not certain of this, are photographers deemed essential services. So if that's the situation in your state, then the broker is going to act as, or the agent will act as the photographer, or the homeowner and the consumer, or will be their own photographer for that virtual tour capability. In some states that do deem real estate essential, there are still provisions about how many people may be in a home. For example, I believe in Washington State, only 2 people may be in the premises at any time. Therefore, that has got to be taken into account when you determine how you're going to capture this video or virtual showing. Who's responsible for it is a question that we got. You work it out with your cooperative broker. If you are the listing broker, you talk to your consumer, is this something that you want to make available, and under what circumstances and how do you want to make it available? Let's decide that. As Renee talked about, there is a copyright component to that. You want to make sure that if your member, the agent or broker is not the one capturing the video, that they are indeed the ones getting the rights and permissions to receive and display the videos. And we do have a lot of forms on our website that specifically if you go nar.realtor/copyright, that can help you get that permission that you need from the brokers. Renee, did you want to add anything on the virtual tour or address a couple other questions?
No, I think you covered it perfectly. Thank you.
Okay, great. And another couple questions we got with regards to the advocacy efforts that I just breezed over. And I did that because the efforts are robust. There is so much information to dive into on our website. Questions about 1031. Yes, we are still working on Congress to get 1031 exchange deadlines moved so that members can take advantage of that even in this time right now. There's questions about whether landlords can claim loss of income from rents not being paid to commercial landowners. There's 2 ways to address that. Of course, we know that the CARES Act is giving some kind of forbearance, mortgage or forbearance to the landlord. The tenant is also getting a moratorium on evictions. But there's the SBA loans. The tenant can apply for SBA loans that could be used to directly pay their rents. And there are also disaster loans and disaster grants available. So again, please check out the details of each of those if you have members asking you questions for that. There were a couple questions about core standards and compliance with updated rules and regulations and certification. And I don't know the answer to that. So unless there's somebody on this panel that does, I invite them to chime in. Otherwise, we will get the answers to your core standards compliance questions and deliver them to you through our amazing association leadership development team. Okay, so last but not least, 2 very brief questions to address. One is with regards to these hold harmless language and liability waivers that some members are creating. That is not surprising in this climate of uncertainty and in our industry that loves disclaimers and getting people to sign disclosures and disclaimers. We're seeing those being used, and they're saying you're taking the risk of entering this home and you will absolve the broker and the agent of all liability should you contract COVID-19. from a legal perspective, those are not compelling. Those are not effective as avoiding liability, because ultimately it's very unclear that there would ever possibly be liability in that scenario. The scenario being a pandemic that is so well known and publicized, the risks are apparent. And so therefore a written piece of document, or, to hold a broker or agent liable for contracting or a client is not a reasonable outcome. And so many brokers are still doing it, I think, because it brings them peace of mind, even though it doesn't bring them necessarily any legal protection. But we will not be producing any or providing any examples because, as I just said, we don't think that they are legally necessary or useful. And then the other question is about fair housing implications. Always abide by the fair housing laws, and there's a lot of contexts in which the fair housing laws can be implicated here. Above all, treat everyone equally. Equal services will help you avoid liability and treat everybody fairly as you are ordered by your code of ethics level of the law to do. And if you're unsure, then please reach out to your legal hotline, or you are the associations providing the legal hotline. So seek guidance from the state fair housing agencies. And also there is a association legal discussion group that is vetting all these questions and debating all of these questions. So please encourage your attorneys to join our base camp group so that we can keep the conversation going. Katie Schatz, I think we've addressed all of the questions in the chat box. And for those who maybe I missed in my speed reading, I invite you to email me or any of the panelists on this call. Our emails are the first initial of our name and then our whole last name, followed by @nar.realtor. So I'll turn it back over to Katie.
Thank you, Katie. Our thanks to you and our amazing legal team for presenting this today. This is obviously a really timely topic and great takeaways. I was taking some notes, so I hope everybody got a lot out of it. And our thanks to all of you for being here. We had about 830 people participating today, so just know that our AE community is still as connected and committed as ever to each other and our members. A few reminders before we sign off. Please be sure to fill out the evaluation form you received after the session. It will be sent to everybody who pre-registered, and your comments help us guide our future programming efforts. The next session is this Friday, April 11th at 11 a.m. Central Time, and the topic is Crisis Communications and Crisis Management. Malin's site, along with some of the AEs who have experienced and worked through crises in their states, will provide valuable information for helping you manage your associations during this unusual time. So be on the lookout for registration information on the Hub, AEI Year-Round Facebook group, and NAR.Realtor AEI landing page. Lastly, all session recordings are available on that landing page for AEI at NAR.Realtor. We appreciate all of you guys joining us, and we hope to see you again this Friday. See you soon.